and then we say intellectual property rights. Is that confusing? So what is the difference? What is intellectual property and what is intellectual property right? What are the two terms? Intellectual property, what does that mean? Please answer, otherwise it's a monologue.
Intellectual property is a matter.
Yeah.
It is like a like skill.
Okay.
And when we talk about intellectual property rights, it's like rights over the property. Right?
Excellent.
Possession over the property.
Very nice. So how is it different from any other property? It's intangible. That's exactly what it is, right? Intellectual property is intangible. So there is a difference, right? If it is a property, you can define the metes and bounds, right? You have documentation, you say length, width, size, and so on. Here it is a little different, right? You have to understand the intangible property. That intangible property is a creation of the mind, okay? And when we say creation of the mind, what kind of properties are we talking about? Answers, please.
Literary work.
Literary work, I hear that. And I need a little more.
Music, dramatic work.
That's all, yeah. Music, dramatic work, yeah. That is copyright. Copyright is the right. The intellectual property would be the creative work, the literary work, drama, invention, what else? Cinematography, what else? Software, yes, wonderful. Designs, yes, that's another one. What else? Computer programs, she said software, so that's similar. Anything else? Sound recordings, yes. What else? AI, yeah. What else? Can't hear you. There was some mischievous murmur. Product design. What else? Integrated circuits, that's a separate one. What else? Logos, yes, that's another one. What else? Semiconductors has been said. Anything else? So you see there's a wide range, right? A whole lot of stuff which is your intellectual property. Okay? Now let's go one by one. Okay, this is a whole spectrum. Each one is defined under a particular kind of right. That right is IPR, right? What you call IPR, correct. So now when we say copyright, yeah, what all comes under copyright? What can you protect under copyright? Yes, beautiful.
Cinematography, sound recording.
Fantastic. What else? Dramatic works, yes. What else? Wonderful. What else? What about software?
Yes.
Yeah, software. And who said algorithms? Who was here somewhere? Computer programs, yes. What about AI? So you see there is a little bit of a problem here. Technology is developing, right? And we have a lot of inventions and advancements with AI. But our patent law,
Old laws.
our law says there is a section which says
Only human.
subject matter which cannot be patented. In that, they say like algorithms, software, mathematical abstractions, these things cannot be patented. Okay? So for that, then again they have another kind of a reading which is called how do you patent or how do you protect computer related inventions. So you have to move with the times, correct? You have to move with the times. And that's what we are also doing in India. Yeah? As a culture, as a community, monetizing intellectual property is not in our blood, right? When you were growing up, what used to happen? If you had 2 candies, you've eaten one and you're full, what would your mother tell you? What to do? Give it to your brother or give it to your friend, right? They never told you to sell it, right? But now to keep with the times, you need to think of monetizing, commercializing. Keep with the times.
change with the times. Keep it for the rainy day. Invest, make money out of it. Okay, so that's how things are changing. So you have to monetize on your intellectual property. So whether it is a dramatic literary work, an algorithm, an invention, something your grandma made, a recipe, or a handicraft, or a breed of mango, you have to protect it. Why do you have to protect it? So that you can claim it as yours. If you claim it as yours, if somebody else wants it, you can charge money for it. You get it? Alright. So, we've understood that intellectual property is a product of the mind. Next slide, please. So now we've understood copyrights, we understand copyrights, we know trademarks, we know designs, we spoke about semiconductor layout designs, we haven't spoken about trade secret. What is a trade secret?
It is a product which is only a company uses it is using the international trade. Also the formulas, basically the pharmaceutical company to use the formula to produce the medicines and all. So this is called under trade secrets because should be protected by the law. Otherwise,
Are trade secrets protected by the law?
yes,
To what extent? What happens if somebody copies it?
they is coming under infringement.
Will a trade secret come under infringement?
No, if somebody pirates that.
Will that be called pirating? If it is a trade secret and not a patent and not under anything else? Think about it and tell me the answer. Meanwhile, we'll move on and I'll come back to you. Don't Google it, think about it. Okay. Now, geographical indications. What is geographical indication?
That is
Where the product is created, meaning by the locality, by the community,
Having the origin to that particular
having the characteristics, beautiful, what else?
From a geographical location.
From a particular location, right? There are a lot of subheadings under this, okay? There are a lot of subheadings under geographical indication. There is appellations, there are right, so many things. But basically, a community which has been doing something, has inherited a skill, a handicraft, a variety, or something which is local to that place. Okay, you protect that so that they get a premium out of that. Alright, that's geographical indication. So are we ready with the trade secrets answer? Yes, please.
Actually, if the company is using that secret for long period of time and they have some market reputation, if someone try to pirate that or also infringe that, it is coming under passing off. In that situation,
That's too much extrapolation. No, it doesn't work like that. So I'll just come to the thing. A trade secret is something which you have inside you, you know, and you don't have legal protection for it. You don't want to patent it. You don't want to disclose it even to a lawyer or even to, you don't want to write it down anywhere. It's a secret which you keep, okay? Now, it can be passed from father to son or whoever it is, and it is kept within the thing, but you don't have a patent protection or any legal protection. It's fine as long as your business goes well. But the flip side of this is anybody can copy it. You don't have protection for it. Okay, so that's the problem with trade secret. See, the word patent means laying open. It's the opposite of the word latent. Latent means hidden, patent means open. Now what happens in a patent is you give out the entire detail in your documentation. Okay, so when it is published, it is open to anybody. In return, what you get from the government or the patent office is a legal protection. Something you say, I tell you everything and you protect it for me for a fee. Okay, that's how the patenting system works. However, you don't want to lay it open. You want to keep it a secret, then the government does not offer you any protection. But as long as the going is good, your trade secret can fetch you the money. But anybody copies it, it is copied. Okay, that's the flip side of trade secrets, right? Okay. Okay, so fine, we've got all that, and then we've more or less, and then there is a Plant Variety Protection Act. Now, plant varieties or hybrids or whatever modified plants, these cannot be patented. All right, just like a dramatic work cannot be patented, it comes under copyrights, right? And designs cannot be patented, they come under another, yes. So that way, the Plant Variety Protection Act is another act which protects the plant varieties. All right, next slide, please. Okay, so we have copyrights, which the intellectual property and the act. That's what I'm showing on this slide. So the copyright provides protection to the expression of an idea rather than the idea itself. Expression of an idea, right? So we all know the Ramayana. Who wrote the Ramayana?
Valmiki.
Okay. So after that, how many people? You have Rajgopalacharyas, you have so many other people, right? So the idea is one thing and the expression of the idea is another thing, all right? That expression is protected under the copyright, all right? Then you have for that you have the Copyright Act, 1957. Trademark, that's the next intellectual property which I have here. It provides protection for symbols, colors, shapes, words, etc. representing and relating to a good or service. It's a sign capable of distinguishing the goods or services of one enterprise from those of others, and it is protected under the Trademarks Act. Then you have the patent, which protects inventions. We have the Patents Act. You have the designs, shape, configuration, pattern, ornaments, etc. Design Act of 2000, GI, we've just spoken about. You have the GI of Registration and Protection Act of 99. You have plant varieties, and then you have the semiconductors. So all the acts are in this. This presentation will probably be made available to you, and you can have it with you. What you have to basically do when you have an intellectual property, you have to, the entire system is it tries to balance the rights and interests of different groups of creators and consumers, okay? So it can ensure knowledge sharing, it can ensure that they are buying genuine goods, it provides pleasure to millions of people, whatever, whether it is a copyright, whether it is a patent or a GI. So basically what you want to see is whether there is a balance between the consumer and the person who provides them, right? So, next. So here is some, how much time do I have exactly? I have time. Oh. Copyright is an exclusive right which is granted to creators on expression of an idea. We already spoke on that. He has the right to reproduce, translate, adapt, perform, distribute publicly, and display the work, etc. Registration is not mandatory. It comes into existence as soon as the work is created, and it is recommended to register a copyright. So what does it give you? It gives you economic rights in the way of royalty. It gives you moral rights, you're acknowledged, and the enforcement of these rights via civil and criminal penalties, right? Okay. So what all? We already spoke on this. I think we covered all of this. Did we leave anything out? We know this really well, right? Okay, go on. So, do you recognize this? What is it? Harry Potter meaning? Hogwarts. That's the school of witchcraft. And you know what happened here? Can you tell me, please?
There was a Hindi movie which was similarly related to it. Which one, ma'am?
The picture over here. That is Harry Potter.
Yeah.
This one. You know the Pandal.
No.
Anybody knows the Pandal story? Anyone?
So this thing was copied. Huh? Yes,
They
yes.
copied actually Disneyland.
Yes. So they copied it, and Rowling came and she said that it's a infringement on my thing. But they let it go because it was for a puja and there was no money being made over there. Do you recognize what is on the other side? You're going to tell, Harry.
It was similarly related to the books written by J.K. Rowling, so even that was
Yeah, so what was similar?
not only the name was also slightly similar, but also the story was very much similar to yes, to those
So
books.
you are familiar with this, right? So then they had to whatever. Okay, so that is copyright infringement. Yeah? Yes. Okay, next. Okay, here do you see the similarities? There is a film called The Graduate, and you see that poster, and you see this actress. Yeah? And then you can see the movie called Anjana Anjani, and you see the other film over here. And Education. The way it is placed also is very similar. When you look here, Zindagi Na Milegi Dobara, and you see lots of, you see how they are, this thing. Yeah, this is something to think about. These all treads on copyright infringement. Next. Okay, now we come to trademark. Alright, here I have something, but can you think about it and tell me, what do you think a trademark, how does it benefit?
It increase the brand value.
How?
When the company produce some product, when they put some logo over there or put some brand name over there, it always increase their reputation that they created that. And also because of customer feedback when they come for them, it always increase their economical growth also.
Right,
It always
brilliant.
improves.
Very nice. Any other takes on trademark?
Helps to identify the goodwill of a particular brand.
Okay. Any other?
Helps to differentiate the
It
product.
yes, your product stands out in the market, right?
Differentiate the product from
Yes.
one company
To the other, right? Okay. So next page, please. So we know this. Here, do you see anything which looks like infringement? What is it? What? Okay. It might look funny, but it isn't funny. Okay. It looks funny, right? Dettol and Dettol, Purell and Purine, right? What are they trying to do? They're trying to cash in on somebody else's goodwill, right? So is that right? It's not, right? You see that? Okay. You see Adidas and Adidolls? You can mistake it, right? So what are you doing there? You're cashing in on somebody else's goodwill and market presence and all that. Okay, these are not correct. You understand that, right? Here what you see, Starbucks and yes. How clever is that? Then you have McDonald's and McDowell's. Is it close? Very close. And if you're not careful, you might think that is the product you're buying. Okay, next. Okay, now can you find the famous trademarks here?
Tata.
Now I want
Tata.
Tata, yes.
Amul.
Amul, okay.
Bata.
Bata, yes. Dettol, yes. What else? Lux, Horlicks, Pepsi is all there. Anything else? Cadbury, yes. Babool is there, yes. Yeah. Horlicks we've already covered.
Lotte.
Pepsi is already done. Huh? Okay, now let us see the next slide. Did we get all that? We got Pepsi, we got Link, we got Amul, Tata, Dettol, Horlicks also we got all of them.
Link.
I think. Well done. Okay, next slide please. Now we come to patents. This is quite dry and we need a little effort. Okay, bear with me. Okay, this is an exclusive right given to an inventor or an applicant by the government for their invention, which is either a new process or product. It's valid for 20 years. It cannot be extended. Okay, so this is the first one which penning. Okay, we'll skip this. Next one. Now, what is patentable? Can you tell me?
Inventions.
New,
Innovative,
industrially applicable,
innovative,
inventive step. Now, when we say inventive step, what do we mean by that?
Something new.
That is a process.
If there is a process, there has to be a new step.
Okay, it has to, if it is a process, it has to have a new step, and if it is not a process, if it is a product,
it should be innovative.
novelty is absolutely a separate filter, right? So we are talking about novelty, inventive step, and industrial applicability. Novelty is one filter, inventive step is one filter, industrial applicability is another filter. Now when we say inventive step, what are we talking about? She said already, if it is a process, it should have a new step. Now, if it is a product, what is it? Okay.
Hmm.
Phone we have the keypad first. Now we have the same phone like touch screen and all camera, sound.
A technical advancement.
New
There-
feature.
A new feature, a technical advancement. It does not have to be a groundbreaking thing. Something should be there and you're improving on it. Alright? Okay, fine. Okay, and no, wait. So we have what, and then how. How do you go about patenting something? There is a process, a patent prosecution process. How do you start with it? Yeah. Okay. Right. You don't have to go to the patent office anymore. It's online. Yes. Yeah. Okay. And then you have to explain. Yes. Okay.
Anything is their opposition, then we have to reply to that. Then they'll publish it.
Yes.
They publish it.
Right.
In the public, if they have any opposition, they can write it after all this process.
Brilliant. Okay. Fine. And what is your time period for that patent? 20 years from when? Yeah. So if the examiner takes 5 years to grant it to you, after that, how long is your time? 15 years. Exactly. So that it's time bound, right? And the clock starts ticking from the time you get your application number. All right. Good. And then where is it valid? You filed for a patent in the Chennai patent office since you're in Bengaluru. Okay. And you want to write patent pending. Your business enterprise is in Tanzania. Okay. Will you get patent protection then? You won't. Absolutely. You have to file or you have to enter the national phase of that jurisdiction to get patent protection there because patents are territorial in nature. Alright, so only in the place where you're protected, where you file for your patent, you get patent protection. Exactly. Okay, fine. Next, please. So the exclusive rights that you get is for making or manufacturing, selling, licensing, using, importing, offering for sale, and distributing. Next. So these are some inventions which you might think are very, very trivial, but at one time they were all patented. Even the safety pin which we use so commonly, right? It was patented at one time, somebody had a monopoly over it for a while, then it came into the public domain after 20 years. Now you get it everywhere for very cheap, right? Even the clothes clip, everything. Next, please. Basic criteria, we've dealt with it. Novelty, inventive step, industrial applicability, all these things make a particular invention patent. Next. So this is a separate section. Section 3, yes. So what is non-patentable? Okay. So non-patentable, we've already spoken of some things, but there are some more things. Contrary to public order and morality, what does that mean? Something obscene will not be granted a patent. Absolutely correct. And what else? Meaning what? Mere invention meaning what? Let us say you invented a lock and key, and a key which can open any lock. Can you go for it for a why? No. Yes, it can be used for some attempt, right? Okay. Method of treatment, why is that not patentable?
It's harmful for the environment.
Right? You understand that, correct? Huh. And then let us take something else. A discovery. A discovery of any kind is not patentable. Why?
It's already in existence.
It already exists, right? There is this concept of prior art. So if you are discovering something, that means there is no human input. It already is there, right? So that is not patentable. So we've spoken about mathematical and any invention that falls under the Atomic Energy Act. That is another part in our patent law. That is also not patentable. Next, please. Now we come to design. So design is a shape, pattern, arrangement of lines, color, which is ornamental, applied to any article. Does it have to have a functional element? Design.
Yes.
It doesn't. It's only the appearance. Okay. So that's what comes under design. That's the main focus of this slide. And it should be applied or applicable to any article by an industrial process. It is registered for 10 years, can extend by 5 years. Next, please. Now, what is the importance? It gives you a statutory right, which accrues on registration. Again, it has the right to prevent all others. Now, just as in patents, right? What do you do in patents? In patents, you prevent others from making, using, or selling, and thereby you get a monopoly, right? You have a negative right. You don't get something directly, you get a negative right. You are preventing others. Similarly, here also you are preventing others from producing, importing, selling, or distributing. The monopoly period of 10 years, extended by 5 years. It is an asset and can be licensed. Next, please. Now the criterion, again, new, original, okay. It must be unique. Applicability of the design should be to the article itself. It should not be against public morality, and there should be no functional feature in that. Next, please. How do you go by, what is the process? You file an application, there is an examination, there is a notification of objection, registration and publication, and then there's a hearing. Now, this kind of a flow chart with minor variations similar throughout, okay? So what you have to file, right, with all your details. It will be, the forms and fees will be examined everywhere. There will be, the content will be examined, and then there will be a communication to you whether it is fine or there is something which needs to be rectified. There might be an opposition, you have to justify your position, and then similar things happen in all the IPs, right? The timelines are different. That's basically what it is. Next, please. Now, do you see any designs here? Do you see any designs on this? The shape of the bottle, yeah. Anything else? The design there, yeah. Okay. Huh? The ring, yeah. And so what would be the IP that you would get for the first one if you have made it?
Copyright.
Okay. Okay. And what would be for the third one? What would that get? Right. And what would be the contents of the Coca-Cola bottle get?
Trade secret.
It's a trade secret so far, right? Right. Next, please. So now we come to geographical indications, just quickly covering this. So it is a sign used on products that have a specific geographical origin, possess qualities, reputation that are due to that origin. So one of the famous one which we are all familiar with is Darjeeling tea. Yeah? You are aware of this, correct? So you also know locally the Mysore silk, Mysore silk, Nagpur orange. We also have the Rasgulla, madam. Yeah, it has some fight as usual. Who gets it? Bengal or Odisha? Bengaluru. Agra Pitha, yes. Mysore Pak has got a GI, not yet. Not yet. Tirupati Laddu has. Yes. What else do you know? Kolhapuri Chappal. What else? Food coffee. Has food coffee got it yet? Yes. Okay. Good.
Chanpatna toys.
Chenpatna toys. I'm aware of that. What else? Banarsi sari?
Yes.
Yes. Okay. Anything else? Pashmina shawls? Pashmina. Yes. Anything else?
Ma'am, Aranmula mirror, Aranmula Kannadi.
Aran?
Mula mirror. Mirror.
Oh yes, that is a famous one from Kerala, isn't it? Chanapoda, I don't know whether it is got. I know the Chanapoda. I love it also, but I don't know whether it has got a GI or not. Paintings, yes. Madhubani paintings. Kolhapuris. Terracotta what? I know that, but from where? Don't try. Does it have a GI? Then you just try to pass it off. This is not passing off. What else? Kanchipuram silks. What else?
Paithani sarees.
Okay, so we are well aware of geographical indications. Next, please. So it's an indication which identifies goods as agricultural goods, natural goods, manufactured goods, originated or manufactured in the territory of a country where a given quality, reputation or other characters essentially attributable to its geographical origin. Next, please. Importance, it gives legal protection, prevents use by others, helps consumers to get quality products of desired traits, promotes economic prosperity. Next, please. So basically, these numbers, Karnataka has much more now. You said Chandni. It's got a GI tag. Okay. I'm sorry. Yeah, okay. Then what else? West Bengal, Odisha, Rajasthan, you see everybody has some, but these numbers have changed. This is not the latest. And I don't even know whether Karnataka leads now. I think Tamil Nadu is higher, right? Yeah. Okay. Next, please. So these are some things which have GIs. Next, please. Handicraft goods. Can you identify these? Pashmina shawl you can identify. That is Moga silk from Assam. And that is Kangra painting from Himachal. Next, please. So you have Feni and yeah. Next, please. Different foodstuffs. Next. Okay, the procedure is an application to be made duplicate. There is a preliminary examination of application, there is acceptance, whatever deficiency found, and then advertisements. Okay. Next, please. So this is the tagline. We all know that Atulya Bharat Ki Amulya Nidhi, invaluable treasures of incredible India. Next. So here we have trade secrets. Okay. Trade secrets, they protect confidential information. Example includes customer lists, manufacturing processes, formulae. They can be protected indefinitely as long as they remain a secret. That's the underpinning of that. If it is not a secret, it's not a secret. You can't do anything. Next, please. So now you also have the PVPA, a legislation that provides legal protection to plant breeders. It was enacted in India in 2001. Okay, next please. It is a law that grants exclusive rights and applies to agricultural crops, horticultural crops, encourages the development of new improved varieties, and it maintains a registry. Okay, next please. Now we have a quiz time. What protects the intellectual property created by artists? Brilliant. What protects the intellectual property created by designers?
Registered designers.
Registered designs. What protects the intellectual property created by inventors? Patents. What of these is champagne? Okay, next please. What does trademark protect?
Logos, names, and
Excellent. In most countries, how long does a copyright last for? 60 years after the death of the person. How long do patents last? 20 years. Next, please. If you write an original story, what type of intellectual property gives you the right to decide? Copyright. Imagine a sports team sets up a company to sell its own range of clothes. What type of intellectual trademark? If a company develops a new technology that improves its main product, technical advancement, patent. Okay, fine. That's all I have for today, and
Questions?
Ma'am, I have a question.
Yes.
So when you go for patents, like patented our product, invented product, so that means when we file an application, we have to provide all the information related to our patented product. That I have no idea. I just need to know what is the difference between the formula or the information we are given to the patented officer as in information regarding our patented product. What is the difference between that and the trade secrets?
Okay. So the trade secret is when you don't tell anyone. You manufacture your goods on your own. You are not asking for protection. Whereas in the patent, what you are doing when you file an application, it's like a deal with the patent office that I'll tell you what I'm doing. You grant me protection for it so that nobody can make use or sell. That's basically what it is. There's nothing else in that. So you are actually sharing the responsibility of protecting your invention with the government. The government will offer you protection. The patent office will offer you protection. Whereas in a trade secret, nobody offers you.
But now
You're yourself.
formulas
Yes.
related to basically the pharmaceutical companies
Yes.
or the other, are they coming under trade secret?
No. I mean, they can. If they choose to, they can. But most pharmaceutical products are patented products.
Yeah.
Yes. So they go through a patenting process. Right?
Thank you.
No.